I'm Dion Tracy Duckett, estate planning and elder law attorney with Duckett Law LLC. Thank you for joining me when I talk about trust. So, what is a trust? A trust is a legal entity that separates legal ownership from beneficial ownership. You can think of it as a treasure chest for the ownership of your property. In your trust, you'll designate agents to manage your property. Initially, when we're talking about a revocable living trust, you'll be the agent who manages your property. And then if you become incapacitated or die, you'll name successors. It also provides instructions for how you want the property to be managed. And because the trust owns your property instead of you, the trust helps you avoid probate. A revocable living trust is a trust that is revocable, meaning it can be amended or canceled altogether. You can put property into it and you can take property out of it. Um, it's living because it's created while you are alive versus a testamentary trust, which is one that's created by operation of your death. Which, for instance, if you want to leave something to your children, you can say, I want to leave it in a trust for my daughter or son. And so that's a testamentary trust. And then there are irrevocable trusts, but that's not the topic of today's conversation. So a revocable living trust is created while you're living and it can be amended or canceled altogether. The benefits of a trust. Benefits of a trust are that you can provide for management of assets if you become incapacitated. That helps you avoid the conservatorship process where the court appoints someone to do that for you. It helps you avoid probate after you die because the property is in the name of the trust and not in your name. And it helps you protect families' inheritance because you can leave property in trust for your loved ones, maybe because they are young and immature or irresponsible, or they may have substance abuse issues, or you may want to protect from a divorcing spouse. And so it allows you to provide management for your loved ones, and it can also provide creditor protection. If you leave property in a trust for your loved ones, then you can say that property is not to be used as collateral or to pay creditors. The other benefit of a trust is that it promotes family harmony because you have specifically stated who you want to manage your property and how you want it to be managed or distributed. When we talk about incapacity planning, by doing your incapacity planning, that can help prevent loss of your assets, loss due to the cost of court proceedings, loss due to other outside factors. Incapacity planning using a trust allows you to designate successor trustees to manage your property. You're designating who you want to serve instead of having a court designate someone who you might not have chosen or even a complete stranger. It allows you to avoid the expensive court process, which costs can include bond, attorney's fees, court fees, and other ongoing fees. You have no say in who is appointed. The process takes away your rights, and it's a public process. Family members may fight over who should be appointed, and again, if family members are fighting, the court may appoint a total stranger. Other incapacity planning tools include the Advanced Directive for Healthcare, which allows you to name healthcare agents to make healthcare decisions for you if you're not able to, and provide living will provisions where you state what you want done if you have a terminal condition or you're in a permanent vegetative state. You can say, I want them to continue to treat me, I want them to allow me to die naturally, or I want a ventilator or feeding tubes or something like that. The financial power of attorney is where you appoint agents to manage property that is not in the trust. The difference between a financial power of attorney and a trust is a trust has very specific instructions on how property is to be managed. Financial power of attorney, on the other hand, sometimes is compared to a blank check. It gives the agent the authority to manage the property, but does not tell them how to manage the property. And then finally, there's guardianship documents for minor children. So you may want to put a power of attorney, temporary power of attorney, or guardianship document in place in the event that you're in a crisis and you're in an accident and you're not available. You're designating who you want to care for your children during such time that you're not able to. So, aspects of the trust. I tend to talk in threes. So, there are threes. First, we talked about the treasure chest. You can think of the trust as a treasure chest that holds your property. The trust is a separate entity and it can hold anything that you can hold, or it can own anything that you can own. So that includes your house, other real estate, investments, business interests, furniture, etc. Then there's the trust agreement, which is basically a book of instructions for how you want the property managed. It designates your successor trustees and it provides instructions for them on how to manage the property. And then finally, there's a pour over will. You have a pour over will just in case you've left property out of the trust, either intentionally or unintentionally. So ideally, you've put most or all of your property into the treasure chest, which is the trust. But if you've left something out, you could have inherited something that you didn't get a chance to put in the trust. Then that small amount of property will go through the probate property process, and the will say put it into the trust, and then distribute it in accordance to the terms of the trust. The will also is where you name guardians for minor children to take care of your children after you die, because the trust does not deal with children, it only deals with property. Parties to the trust. So, first, there are three. The trust maker, that's the person who creates the trust and then funds the trust. When we say fund the trust, we're saying that's putting the property into the trust or doing beneficiary designations that transfer property to the trust. Then there's the trustees. The trustees are the people you name to manage the trust. They're managing the property that's in the trust in accordance with your instructions that you've put in the trust. There's successor trustees for incapacity and for death. There can be joint trustees versus sole trustees. If you name joint trustees, they have to act together. There are interested trustees and independent trustees. Interested trustees are people like the beneficiary. They have an interest in the trust, or someone who's subordinate to the trust, to the beneficiary, meaning they report to the beneficiary or related to the beneficiary. An independent trustee is someone who is not subordinate to the beneficiary or is not a beneficiary themselves, or is not a beneficiary or is not subordinate. Let's see. And then finally, there's the beneficiary. The beneficiaries are the people or person who benefits from the trust property. The trustees manage the trust property for the benefit of the beneficiary. Now there's 3 life stages. So the first stage is alive and well. With the revocable living trust, when you're alive and well, the trust maker is you. The trust maker is always you. The trustee, the person who manages the trust, is you, unless you've decided you don't want to do it. Then you can name someone else, or you can name a co-trustee. The beneficiary is also you. So you've created the trust. You are managing the property that's in the trust, and you are managing it for your benefit. Then, if you become incapacitated, you're still the trust maker, but then you've named successor trustees, and you've named backup successor trustees in case the first person you name can't act or does not want to act. And then you're the beneficiary. So when you're incapacitated, the successor trustee is managing the property according to the instructions that you've put in the trust agreement, and they are managing the property for your benefit. Then the third stage is death. After you die, you are still and always the trust maker. Then you've got death trustees. They can be the same or different from the incapacity trustees. And you can have individual or joint death trustees. And the beneficiaries are whoever you name. That can be your children, family members, your college, other institution, your church. So those are the beneficiaries. And the trustee is managing and distributing the assets in the trust to the beneficiaries, or managing for the beneficiaries, according to your instructions. So that is the Revocable Living Trust in a nutshell. See you in the next video.